The Supreme Court has confirmed the president's constitutional power to declare a state of emergency in any state facing a potential breakdown of law and order or descent into anarchy. The decision arose from a legal challenge brought by Adamawa and 10 other states governed by the People's Democratic Party, PDP. The plaintiffs contested President Bola Tinubu's declaration of emergency rule in Rivers State, which included the 6-month suspension of elected state officials. The court dismissed the suit after upholding preliminary objections on jurisdictional grounds, but proceeded to address the merits, ultimately ruling in favor of the executive's action. In a lone dissenting voice, Justice Obande Ogbuinya argued that although the president may declare an emergency, this power cannot extend to suspending democratically elected officials, including governors, deputy governors, and lawmakers. Jiti Ogunye is the principal counsel at Jiti Ogunye Chambers. He joins me now to put this development in proper perspective. Thank you very much for giving us your time. Okay, I don't think we have him. We'll just try and reconnect and have that conversation. Okay, if you can hear me, sir, could you just acknowledge? I think your device is muted.
Yes, I can hear you.
Okay, great. So let's just establish something. Is this ruling, I mean, ordinarily we'll understand that it has affirmed what is in the Constitution, but does it also confirm or affirm that democratically elected officials can be suspended during the state of emergency declaration?
That's what the judgments of the Supreme Court is affirming. And I know that this was a big debate while the state of emergency in Rivers State lasted. And the central question we focused then was whether, indeed, in exercising the declaration of the state of emergency powers under Section 305 of the Constitution, with the National Assembly concurring, if the president indeed could order the suspension of the governor of a state or suspend a democratically constituted House of Assembly. And on these opinions were divided, but it's like the Supreme Court has rested that today by interpreting emergency powers, which are not defined in the Constitution, or extraordinary powers or measures, which are not defined in the Constitution. And the judgment of the Supreme Court now is affirming, without any doubt, that suspension of the democratically constituted structures could be one of those extraordinary measures that could be taken under the declaration of the state of emergency.
Okay, what should Nigerians make of that one different opinion that says, although the Constitution empowers the president to take that decision, it doesn't seem to also give him the authority to suspend democratically elected governor? Help us understand that position and what Nigerians should make of it, even though we know now that the ruling has stated what is.
Well, there's a dissenting opinion on that issue, and the dissenting opinion is not a majority judgment. The court's judgment is the majority decision, even if there's a dissenting opinion. But I think that opinion speaks to the possibility of abuse of power, including the abuse of declaration of emergency powers by any incumbent president, who may indeed exploit this provision nefariously. And I think that the safeguard for me in a democracy such as ours is that a National Assembly should be alive to its responsibility. Too often people tend to think that it's only a president alone, acting alone, that can exercise emergency powers. No, if the president gives a notification of a state of emergency by way of proclamation, if the National Assembly within the stipulated time does not affirm it, that proclamation is spent. So indeed, we're dealing with concurrence of powers between the federal executive and federal legislature. So the third arm of the government is the judiciary, which is not part of it and which now had an opportunity to look at what have been done by the two arms of government. So I think that the safeguard could well be a National Assembly that is alive to its responsibilities, where there are representatives that can debate this matter and then disagree with a seemingly overbearing president, if that's the case. But once there's a concurrence, I think that the judiciary, the third arm of the bill, may not have much to do in trying to invalidate such a declaration.
Okay, given Nigeria's history, I mean, we had a military role, and we also have seen instances of executive overreach. Do you see this ruling as a step backward or forward for constitutional democracy, or just a necessary clarification in law?
Look, I know that this is an emotive subject. When the matter was vividly debated and contested in the public domain, when that declaration was done, many pundits, including legal giants, opined that although the Supreme Court had not dealt with the matter directly, on previous occasions the Supreme Court had declined jurisdiction in favor of those who wanted to trigger that jurisdiction, and that still re-echoed even in today's judgment. Many people gave their enlightened opinion, but there are also a number of people who said that those who are saying that removal of a governor could not in any situation be part and parcel of the declaration of state of emergency were wrong. I'll give you an example, because on that occasion, I said that many people, are wrong on that matter by insisting that in all situations, a governor could never be removed under or suspended under a state of emergency. And I gave an example then, and I give it now, short, that if a House of Assembly of a state were to declare sovereignty from Nigeria, were to say that a state had become a country, pass a resolution and authorize a governor to carry out that resolution by declaring himself the president. If a state of emergency is declared in Nigeria by a president, concurred with by the national legislature, will that governor in that instance be removed? Would that House of Assembly in that instance be dissolved? Of course, this will happen. Not only that, that governor is likely to be arrested and charged with treason, even while his so-called term is still in existence. So I think that people who are discussing this matter largely then were just fixated on the political side. I insisted that the jurisprudential essence should have been looked at thoroughly, so that those who are excluding the possibility of a removal of a government in all situations will not say that. If the argument was that, we have not reached that threshold for a suspension of the government, it will have been a different argument. But for them to insist that in no situation under a declaration of state of emergency will the government be suspended, I think that they missed the point. And I agree with the Supreme Court on today's ruling, which is very rounded and robust, rather than the one-sided argument being peddled by a number of people while that matter lasts.
Now, you've touched a bit on it, but I still want to go ahead and ask, to what extent does this court's interpretation of extraordinary measures under Section 305, 3C and D risk undermining federalism principles? In Section 2, subsection 2, of the Constitution, how should this precedent apply to politically motivated declarations in opposition-led states?
I would say that, Nigerian federalism is defined by the Constitution. Nigeria is called a federation, and the powers are defined, shared between the central government and subnational government. Now we have local governments that are third, in the tiers. Now, my view is that the decision of the Supreme Court today has not in any way encouraged undermining of federalism or federalist principles as defined in the Nigerian Constitution, because we are practicing federalism in Nigeria as defined by the Nigerian Constitution. And if legislators, believe that that power under Section 305 should be further circumscribed or limited to prevent abuse. For example, in amending the Constitution, extraordinary powers can be defined under that section or under the general section of interpretation of the Constitution, so that you not resort to the ordinary meaning or constitutional or dictionary meaning of extraordinary measures, so that it will not be nebulous and left open. We may then be prone to abuse and to the kind of undermining that you refer to in your question. If that does not happen, then even in the future, if there are situations in which you have the possibility of an emergency and there's going to be a declaration of emergency, the president will still be open to being accused of being whimsical and being subjective in determining what is extraordinary, because there will be no objective definition in the Constitution of what's an extraordinary measure that should be taken is. I think that that's the best way to deal with it. I don't think that the Supreme Court in judgment today has encouraged any undermining of federalism in Nigeria, of federalist principles.
Thank you very much for sharing your thoughts on this subject. We appreciate it.
Yes, my pleasure. Thanks for that.